Sometimes the prosecutor and the defense lawyer will agree to a plea bargain to reduce a DUI case down to what we call an exhibition of speed, or speed X. And really, all that means is that the client agrees to plead to this offense, which essentially is like drag racing, okay, or a speed contest, instead of DUI. Now, the first question a lot of people ask is, well, can I do this because I wasn't really speeding, I wasn't going that fast? And the answer is yes. I mean, by doing this, we're not saying that you were drag racing or you're going really fast. We're basically saying that it's a lot more palatable to take an exhibition of speed than a DUI on your record. And therefore, we've just agreed to call this offense a speed X instead of a DUI. Now, a speed X in a DUI case is a very good outcome, generally speaking. A lot of times it takes a lot of maneuvering and a lot of convincing to get the prosecutor and the judge to agree to it and go along with it. But when you can do it, there's definite benefits to the client to getting an exhibition of speed versus a DUI. And I'm going to discuss those benefits now. First of all, the probation period is shorter. Usually on a DUI, you're going to get 3 to 5 years probation. On a speed X, it's usually 1 to 2 years. Secondly, the fine is less. Third, a speed X does not require any DUI school, whereas a DUI is going to require between 3 months to up to 3 years of DUI school. A speed X does not require any minimum or mandatory jail time. A speed X conviction does not trigger a license suspension. Now, there's a caveat there because if you're charged with DUI and you get it reduced to a speed X, being convicted of the speed X in court is not going to trigger a license suspension, but you're also going to have a DMV hearing, most likely. And if you lose that DMV hearing, then you can still get a suspension that way. So you're going to have to win a battle on 2 fronts, at the DMV and in court. But with the speed X, at least in court, you've won that battle and there's no license suspension. And a speed X can be even more valuable in a second or third time DUI case, because there you're looking at mandatory jail time, sometimes in a third time, for example, 4 months of jail. Whereas if you get it reduced to a speed X, there's no mandatory jail time at all. Now, the other great benefit to a speed X, aside from sentencing, is that it does not count as a prior on your record. So in California, if you're convicted of DUI or the lesser offense of wet reckless, then you have a DUI on your record. And for the next 10 years, if God forbid you wind up in this situation again and you get another DUI, your new DUI is going to count as a second offense, right? And as a second time DUI, the penalties are exponentially greater. But if the original DUI was knocked down to a speed X, then it doesn't count as a DUI in your record, and your new case is just going to be first time DUI. And a lot of people come to me and they say, look, this has been a wake-up call for me, and I've learned my lesson, and I'll never get caught drunk driving again. And I hope that's true. I mean, they would be wise really not to drink and drive again. But 10 years is a long time, and you never know what's going to happen. And you may be at a wedding, at an event, having a few drinks, go home, and God forbid get in this situation again. And if you do, it's much better not to have a prior DUI in your record. And with a speed X, you don't. So for all of these reasons, in situations where we can really work up the case and convince the prosecutor and the judge to go along with reducing the DUI to exhibition of speed, it can be a definite benefit for the client.